The Trump administration wants to erase one of our most fundamental rights that's in the U.S. Constitution, birthright citizenship. Let's walk through a brief history of birthright citizenship in the United States. Let's break down what it is, where it came from, and why it matters right now. Because Trump's legal team is trying to rewrite the Constitution. To understand birthright citizenship, we need to start with the Dred Scott decision. In 1857, the Supreme Court ruled that black people were not U.S. citizens, and this helped spark the fight for constitutional change. Before that, we had to have a civil war. During the Reconstruction period after the Civil War, the three major amendments that were ratified included the 14th Amendment, which guaranteed citizenship to all born in the United States, including formerly enslaved people, establishing birthright citizenship. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The phrase, subject to the jurisdiction thereof, is the piece that Trump's legal team is trying to exploit. They're arguing that it means that children of undocumented immigrants, because their parents are not legally here, are not truly subject to the jurisdiction of the United States. But case law proves otherwise. This Supreme Court case you all need to know about because it set a legal precedent. U.S. versus Wong Kim Ark, 1898. In this case, the Supreme Court ruled that anyone born on the U.S. soil is a citizen, even if their parents are not citizens, because Wong Kim Ark was born in San Francisco to Chinese parents who were not U.S. citizens, and the court said that didn't matter. This decision established something called jus soli, citizenship by birth on U.S. soil. As the law of the land, it has been upheld repeatedly ever since. Now, in 1884, Native Americans born on the tribal land were denied automatic citizenship, which narrowed the 14th Amendment's reach. But in 1924, the Indian Citizenship Act was when Congress granted citizenship to all Native Americans born in the U.S., closing a long-standing exclusion. If you notice here, you have to fast forward decades later. In 1982, in Plyler versus Joe, the court ruled undocumented immigrants are within U.S. jurisdiction, reinforcing protections under the 14th Amendment. So, from the 1970s into the 1990s, Congress repeatedly tried and failed to restrict birthright citizenship, which reaffirmed its constitutional strength. Trump tried again during his first term. And with his new executive order, he is denying citizenship to U.S.-born children of undocumented immigrants, and this is facing a legal showdown in the Supreme Court this month. You can see in this headline. But just keep in mind that legal scholars across the spectrum, liberal and conservative, have called the argument deeply flawed and radical. Oh, and the only exceptions ever to birthright citizenships have been children of foreign diplomats, children of enemy soldiers occupying U.S. territory, and children of Native American tribes in 1868, because tribes were treated as sovereign nations. But then again, as I told you, it changed in 1924. Undocumented immigrants don't fall into any of those categories. What Trump's administration is trying to do goes against the fundamental mission of this nation, as outlined in Emma Lazarus' great poem. Let's just hope the Supreme Court uphold the law.